I, Harshali Chowdhary, Additional District and Sessions Judge, cum faculty member, Chandigarh Judicial Academy, welcome you all. In this session, we shall be taking up the important judgments for the month of November 2022. Without further ado, let's take up the important judgments. Now, the first judgment that I shall be taking up would be from Civil Procedure Code. The case is Maringamai Acham versus Maringamai Kuripau. In this case, plaintiff filed an injunction. The trial court declined his request for interim injunction. The plaintiff died during the appeal, thus the appellate court allowed the legal representatives to be heard. Later, the High Court concluded that the litigation was abated by the death of the single plaintiff and was not unsettled by bringing on record the legal representatives in time. However, it was held by Honorable Supreme Court that the impleadment of legal representatives by an appellate court in an appeal from an interlocutory order will affect the suit itself. Next judgment is Raj Process Equipments and Systems versus Honest Derivatives Private Limited. In this case, in December 2017, the plaintiffs filed a damage suit in Civil Court Senior Division, Jalgaon. The trial court ordered the litigation to proceed without two defendants' written statements since they did not submit in time. As the other two defendants had not appeared, the court ordered the proceedings to proceed ex parte. This case was transferred to commercial court. The defendants filed petitions for delay condonation, recalling the no statement order against defendant number 1 and 2, and setting aside the ex parte order against defendant number 3 and 4. The judge dismissed this application based on Order 8, Rule 1 CPC. The High Court maintained the trial court's order by citing SCG Contracts India Private Limited versus KC Chamankar Infrastructure Limited. However, Honorable Supreme Court observed that time limit for filing written statement is not mandatory when the suit was instituted before the normal civil court and transferred to a commercial court after the expiry of 120 days. In the case of Gurdev Singh versus Harvinder Singh, plaintiff sued defendant for permanent injunction. The defendant filed an application under Order 7, Rule 11 CPC seeking rejection of the plaint, but the trial court dismissed it, holding that the plaint prima facie disclosed the plaintiff's cause of action. In a petition to the High Court, the defendant argued that a simpliciter suit for permanent injunction is not maintainable because the plaintiff has not sought a declaration. High Court, however, dismissed the petition. It was held by Honorable Supreme Court that the plaint cannot be dismissed under Order 7, Rule 11 CPC on the ground that the plaintiff is not entitled to any relief. In the case of Bojraj Garg versus Goyal Educational and Welfare Society, the decree holder in this instance appealed before Honorable Punjab and Haryana High Court a decision of the executing court that denied his request for an early hearing of his March 20, 2019 execution petition. However, Honorable High Court declined to intervene. He appealed to the Honorable Supreme Court stating that the executing court is not implementing the instructions in Rahul S. Shah versus Jinendra Kumar Gandhi. It was held by Honorable Supreme Court that the mandate in Rahul S. Shah versus Jinendra Kumar Gandhi is to be followed. The executing court must decide the case within 6 months of filing and give written reasons if it cannot. Next is the case of Bank of Rajasthan Limited versus VCK Shares and Stock Broking Services Limited. In this case, Bank of Rajasthan sued VCK Shares and Stock Broking Services Limited, being the borrower. The borrower filed a civil suit in Honorable Calcutta High Court to sell pledged shares, recover sale proceeds, inquiry losses, and decide on payment. While the suit filed by the bank against the borrower was barred, but the borrower's suit was not, as held by Honorable Calcutta High Court. Two apex court judges heard the bank's appeal of this order. The case was referred because of conflicting rulings. It was held by Honorable Supreme Court that the RDB Act does not restrict a defendant from suing a bank in a civil court. Defendant chooses. The RDB's Act debt collection procedure does not eliminate a borrower's civil action entitlement. a defendant may file a counterclaim or follow the court's more onerous procedure. Civil court can try suit filed by borrower against bank but has no power to transfer it to DRT. Now coming to the case from Contract Act. In the case of Food Corporation of India versus Abhijit Paul, there was a contract between FCI and transport contractors. Now, the question before Honorable Supreme Court was that can the corporation recover demurrages imposed by the railways as charges under this clause? The corporation has not chosen to recover demurrages under this contract. Therefore, it was held that charges cannot include them. Although demurrage is a charge, but this textual understanding won't help to comprehend the party's genuine meaning. Next is the case from constitutional law, that is Janhit Abhiyan versus Union of India. Now it's in a 5 judges bench in a 3:2 majority. The Honorable Supreme Court upheld the 103rd constitutional amendment providing 10% economic weaker section reservation, which introduced 10% reservation in education and public employment. It was held that 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation based on economic criteria, permitting the state to make special provisions in relation to admission to private unaided institutions, and in excluding the SEBCs, OBCs, SC, STs from the scope of EWS reservation. Next is the case from Criminal Procedure Code. It is A versus State of Karnataka and another. In this case, bail granted to the accused was challenged by the prosecutrix in the Honorable Supreme Court. Observations made by Honorable Karnataka High Court were that complaint was filed after 5 days and the allegations that the accused had mixed some substance in the drinks that made her lose consciousness, and thereafter he committed the offense on intoxicating her and subjected her to the sexual act is a matter of trial, and the accused is in custody from 11th of February 2022, and there was no need of further custodial trial. Accordingly, Honorable Karnataka High Court granted bail to the accused. However, it was held by Honorable Supreme Court that time is needed for rape survivor to come out of trauma, and it needs to be considered at the time of deciding the bail vis-a-vis delaying in lodging the FIR. Therefore, the order passed by Honorable High Court was set aside. Next is the case of Divya Bharti versus State of Bihar. Divya Bharti, a panchayat teacher, sought anticipatory bail after FIR was filed against her for offences under IPC sections 420, 467, 468, 471 and 120B. Her pre-arrest bail was conditioned on her returning her panchayat teacher's salary. She must return her entire income in 18 equal monthly installments and forfeit her panchayat teacher position. In her special leave petition, she questioned this direction and argued that the High Court's onerous bail requirements are untenable. It was held by Honorable Supreme Court that additional conditions of repaying her panchayat teacher salary is neither justifiable nor required by law while granting her pre-arrest bail. As such, the conditions were set aside. In the case of Vinay Prakash Singh versus Sameer Gehlot, Shivinder Mohan Singh was convicted of contempt of court on 22nd of September 2022. In his miscellaneous plea, he argued that he was already in jail in connection with another case when he was brought from jail number 7, Tihar Jail, New Delhi, to the Supreme Court on 3rd of February 2020. He sought a clarification that the 6-month prison term will begin on 3rd February 2020 instead of 22nd September 2020 by invoking Section 428 CRPC. It was held that Section 428 CRPC requires a conviction. A conviction must lead to incarceration. It must be for a term and not in default of fine. To be invoked, the convict must have been detained during investigation, inquiry, or trial in the same case. If these conditions are met, the convict is entitled to set off for his confinement. Next case is Buri Bai versus State of Madhya Pradesh. In this case, the Madhya Pradesh High Court cancelled an accused bail because the trial court hadn't considered the fact that he was absconding and was later arrested. The accused was charged under Section 304B, 498A, Section 34 IPC, and Section 3 of Dowry Prohibition Act. It was held by Honorable Supreme Court in its appeal that the High Court's power was not to appeal or revision but to cancel bail under Section 439, subsection 2 CRPC. Cancellation of bail cannot be ordered for the accused perceived indiscipline before bail. The powers of cancellation of bail cannot be approached as disciplinary action against the accused. In a situation where a bail has already been granted, it's upsetting under Section 439, subsection 2 CRPC is anticipated only in such cases where the accused liberty is going to counterbalance the requirements of a proper trial of the criminal case. Unless a strong case based on any supervening event is made out, an order granting bail is not to be lightly interfered with. Next is the case of Girisan Nayyar versus State of Kerala. In this case, Honorable High Court of Kerala confirmed the accused conviction under IPC Section 143, 147, 148 and Section 3 of the Prevention of Damages to Public Property Act 1984, read with Section 149 IPC. Test identification parade was key to the conviction. The accused allegedly participated in a violent protest against Kerala's decision to delink pre-degree courses from the colleges and launch +2 courses in schools. The protesters damaged 81 KSRTC buses, killing a bus conductor. In their appeal against their conviction, the accused questioned the veracity of the eyewitnesses who participated in the TIP to identify the accused, the delay in conducting the TIP, the validity of the TIP and the presence of the investigating officer during the TIP. In its judgment allowing the appeal, Honorable Supreme Court first discussed the law regarding test identification parade and held that if identification in the TIP has taken place after the accused is shown to the witnesses, then not only is the evidence of TIP inadmissible, even an identification in a court during trial is meaningless. Even a TIP conducted in the presence of a police officer is inadmissible. The evidence of a TIP is admissible under Section 9 of the Indian Evidence Act. However, it is not a substantive piece of evidence. Instead, it is used to corroborate the evidence given by the witnesses before a court of law at the time of the trial. Therefore, TIP, even if held, cannot be considered in all the cases as trustworthy evidence on which the conviction of an accused can be sustained. Threefold object of conducting TIP are necessary to eliminate the possibility of the accused being shown to the witnesses before the test identification parade, TIP to be held without avoidable and unreasonable delay after the arrest of the accused. There should be a healthy ratio between suspect and non-suspect during a TIP, and TIP is not just an empty formality. Next is the case of P. Ponnuswamy versus State of Tamil Nadu. In this case, the Supreme Court in the ratio of 2:1 held that an accused has a right to receive the list of the statements, documents, material, etc. in the possession of the prosecution, even if draft rules of criminal practice are not yet adopted. Next case is Ashok Kumar Chandel versus State of UP. In this case, Honorable Allahabad High Court reversed the trial court's acquittal and convicted all the accused under Section 148, 302 read with Section 149 and 307 read with Section 149 of Indian Penal Code. While acquitting a murder suspect, the trial court refused to consider a ballistic report because it was not self-signed by an assistant director, but rather a scientific officer's report was forwarded by the assistant director. The High Court allowed the appeal, but noted that the report could not be discarded. On this point, Honorable Supreme Court held, while affirming the High Court's view, that Section 293 is in fact complied with, as a report should be treated as under the hand of the government scientific expert, being the director, deputy director, or assistant director of a central forensic laboratory or a state forensic laboratory as provided under Section 293, subsection 4 CRPC. State of Himachal Pradesh versus Mastram was referred to. Next is the case of Naveen versus State of Haryana and others. In this case, the trial judge denied the complainant's request under Section 319 CRPC to summon a suspect in a rape case. In her plea to the court, the complainant said that she had named the accused in her initial version, but police did not challan them in collusion. Honorable Punjab and Haryana High Court later overturned the order and allowed the application. It was held by Honorable Supreme Court that power under Section 319 CRPC is a discretionary and extraordinary power which should be exercised sparingly and only in those cases where the circumstances of the case so warrant. And the crucial test, as held in the case of Hardeep Singh versus State of Punjab and others, has to be applied, which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, will lead to conviction. Referring to the evidence on record, the bench held that if unrebutted, it will not be sufficient to convict the accused. Hence, the order passed by Honorable High Court was set aside. Next is the case of Iga Somaya versus M. Mahindra Reddy and others. Here, the contempt petitioner alleged that the accused was given a copy of her daughter's Section 164 CRPC statement, thereby violating the mandatory directions issued by Honorable Supreme Court. It was held by Honorable Supreme Court that accused is not entitled to the copy of statement under Section 164 CRPC before cognizance is taken. The right to receive a copy of such statement will arise only after cognizance is taken and at the stage contemplated by Section 207, 208 CRPC and not before. Directions in the form of mandamus to all the police stations in charge in the entire country were issued to follow the directions of Honorable Supreme Court as laid down in the case of State of Karnataka by Nona Naveen Kere Police versus Shivanna alias Tarkari Shivanna. Upon receipt of information relating to the commission of the offense of rape, the investigating officer shall make immediate steps to take the victim to any metropolitan or preferably judicial magistrate for the purpose of recording her statement under Section 164 CRPC. A copy of the statement under Section 164 CRPC should be handed over to the investigating officer immediately with a specific direction that the contents of such statement under Section 164 CRPC should not be disclosed to any person till charge sheet or report under Section 173 CRPC is filed. The investigating officer shall, as far as possible, take the victim to the nearest lady metropolitan or preferably lady judicial magistrate. The investigating officer shall record specifically the date and the time at which he learnt about the commission of the offences of rape and the time and date at which he took the victim to the metropolitan or preferably lady judicial magistrate as aforesaid. If there is any delay exceeding 24 hours in taking the victim to the magistrate, the investigating officer should record the reasons for the same in the case diary and hand over a copy of the same to the magistrate. With regard to the medical examination of the victim under Section 164 ACRPC, it imposes an obligation on the part of the investigating officer to get the victim of the rape immediately medically examined. A copy of the report of such medical examination should be immediately handed over to the magistrate who records the statement of the victim under Section 164 CRPC. Every High Court that the appropriate directions, modification, amendments be made to the criminal practice or trial rules incorporating the provisions consistent with the directions issued by Honorable Supreme Court in the case of Shivanna and A versus State of Uttar Pradesh. Next is the case of Muhammad Abid versus Ravi Naresh. A special leave petition against Honorable Allahabad High Court judgment quashing magistrates under Section 146 CRPC order was filed. The issue involved was with regard to a land in Mohalla Anguri Bagh, Faizabad, Uttar Pradesh, with shops and a house on it. In this case, it was held by Honorable Supreme Court that the proceedings under Section 145, 146 CRPC must come to an end once the civil court is seized of the matter. The inter se rights of the parties regarding the title or possession are eventually to be determined by the civil court. Now coming to the cases under Indian Penal Code, the first case would be Jaykaran Yadav versus State and City of Delhi. The man was charged with murdering his wife and the only eyewitness was their 7-year-old daughter. Honorable Delhi High Court upheld his conviction under Section 302 IPC. Before Honorable Supreme Court, the accused argued that even if the occurrence is taken as it happened, it was spur of the moment. It was held by Honorable Supreme Court that there was no premeditation for the death. It happened spontaneously. Realizing his mistake, the accused rushed his wife to the hospital, but she died. Honorable Supreme Court partially upheld husband's appeal against wife's murder conviction and modified the sentence to Section 304, Part 2 of IPC. Next is Somai versus State of Madhya Pradesh. It was held that once a court believes a survivor of sexual assault, it is sufficient to establish an offence punishable under Section 376 of the Indian Penal Code, and the failure of the police to send seized articles to the forensic science laboratory would not affect the outcome in such a case. The Supreme Court thereby confirmed the conviction of a rape accused. Next is the case of B.A. Umesh versus Union of India. In this case, accused was sentenced to death for rape and murder of a housewife. He was imprisoned in solitary confinement and isolation from 2006 to 2013, which was without legal authorization and utterly anti-ethical to the principles laid out by Honorable Supreme Court in the case of Sunil Batra versus Delhi administration and others. It was held that solitary confinement had negative health impacts. The accused is entitled to have his death sentence commuted to life in prison. He must serve a minimum of 30 years before any remission application can be considered. If no remission is granted, he will be imprisoned for the rest of his life. Next is the case of Muhammad Arif alias Ashfaq versus NCT of Delhi. In this case, intruders opened fire on 22nd December 2000, killing 3 people, including 2 7th Rajputana Rifle soldiers. Pakistani Muhammad Arif was arrested on December 25th, 2000. On October 24, 2005, he was convicted and sentenced to death. Honorable Delhi High Court's 13th of September 2007 judgment confirmed his death sentence. Honorable Supreme Court rejected his appeal on August 10, 2011 and his review petition on August 28, 2011. However, in 2016, Honorable Supreme Court reheard his review petition after holding that death penalty review petition must be heard in open court. Supreme Court postponed RF's execution on April 28 of 2014. The review petition argued that the courts erred in admitting phone records as evidence without a certificate under Section 65B of the Indian Evidence Act 1872. It was held by Honorable Supreme Court that the decision in Anwar PV versus BK Bashir and others, as clarified in Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorantyal and others, is the law declared on Section 65B of the Evidence Act. It was observed that consequently we must eschew for the present purposes the electronic evidence in the form of CDR, which was without any appropriate certificate under Section 65B subsection 4 of the Evidence Act, even after eschewing circumstances H and J which were directly attributable to the CDRs relied upon by the prosecution. The other circumstances on record do clearly spell out and prove beyond any doubt the involvement of the review petitioner in the crime in question. Accordingly, the review petition filed by the petitioner was dismissed by Honorable Supreme Court. Next is the case of S. Kaliswaran versus State by the Inspector of Police. Now, according to the prosecution in this case, in July 2007, the accused conspired to steal an ambassador car and kill its driver. The accused allegedly murdered and buried the man. Police said that the suspect sold the car and split the cash. A trial court in Coimbatore convicted and jailed the 5 accused, and after the investigating officer presented a charge sheet. Madras High Court upheld the trial court's conviction of the present accused. The conviction was challenged in a murder case based on circumstantial evidence was ultimately set aside by Honorable Supreme Court. It was held that when the extrajudicial confession is not duly proved or does not inspire confidence or is not corroborated by any other reliable evidence, the conviction could not be based solely on such weak piece of evidence. If there is considerable time gap between the persons seen together and the proximal time of the crime, the circumstances of last seen together, even if proved, cannot flinchingly fasten the guilt of the accused. Though identification of the deceased through superimposition is an acceptable piece of opinion evidence, however, the courts generally do not rely upon the opinion evidence as the sole incriminating circumstances given its fallibility, and the superimposition technique cannot be regarded as infallible. In a case of circumstantial evidence, motive plays an important link to complete the chain of circumstances, which was missing in this case. Next are the cases from Indian Evidence Act. The first case would be Rahul versus State of Delhi Ministry of Home Affairs and others. In the death reference matter, the DNA profiling methodology and statistical analysis was reiterated as laid down in the case of Manoj versus State of Madhya Pradesh and others by Honorable Supreme Court. In this case, accused was convicted for the commission of offense of rape, abduction, and murder with death sentence on which on the later acquitted by Honorable Supreme Court on the grounds of shoddy investigation, circumstances of the arrest of the accused, non-proving of circumstantial evidence, discoveries and recoveries of the incriminating articles, want of certificate under Section 65B of CDR, identify of the indica car, the seizure and sealing of the articles, collection, preservation, and report of forensic evidence not proved, identification of the accused not established, vital documents and police witnesses not examined, illegal reliance on the alleged disclosure statement of the accused as extrajudicial confession having been hit under Section 25 Evidence Act. It was also observed by Honorable Supreme Court that vast and unrestricted powers of the trial court are there under Section 165 of Evidence Act, which was also held in the case of State of Rajasthan versus Ani alias Hanif and other. Despite the acquittal of the accused person, the Honorable Supreme Court held that the family of the deceased was entitled to a compensation under Section 357A CRPC. Next is the case of Sirikonda Madhava Rao versus N. Hemlata. The trial court in this case exhibited a document that seemed to be an unregistered sale deed. Later, the defendants made an application to de-exhibit the documents pursuant to Section 151 CPC, and the trial court allowed the request. The petition contesting this order was dismissed by Honorable Telangana High Court. Honorable Supreme Court noted that the order directing the document to be demarked and not treated as an exhibit is incorrect in its order on appeal. It was held that once a document has been admitted in evidence, such admission cannot be called in question at any stage of the suit or proceedings on the ground that the instruments has not been duly stamped. Objection as to the admissibility of a document on the ground of insufficiency of stamp has to be raised when the document is tendered in evidence. Therefore, it is not open to the parties or even the court to re-examine the order or issue. The law laid down in Javed Chand and others versus Pukrat Surana and Shamal Kumar Roy versus Sushil Kumar Agarwal were referred to. Next is the case from Juvenile Justice Care and Protection of Children Act 2015. In the case of the state of Jammu and Kashmir, now UT of Jammu and Kashmir and others versus Shubham Sangra, the case involves the 2019 gang rape and murder of an 8-year-old girl in Kathua. A Pathankot Special Court sentenced 3 men to life in June 2019. 3 police officers were given 5-year sentences for destroying the evidence. The Juvenile Justice Board was held to try Shubham Sangra. Shubham Sangra was the nephew of Sanji Ram, the temple's caretaker. Honorable Supreme Court moved the trial from Kathua to Pathankot, Punjab, because lawyers obstructed justice by protesting the police detention of the accused. Later, based on a physical, dental, and radiological examination of the accused, that is Shubham Sangra, the Special Medical Board estimated his age to be 19 plus. Sangra filed a claim as a juvenile with the CGM Katua under Section 8 of the Jammu and Kashmir Juvenile Justice, Care and Protection of Children Act 2013, which was allowed. Honorable High Court maintained the CGM order. However, it was held by Honorable Supreme Court that the accused was not a juvenile at the time of commission of the offence and should be tried the way other accused were tried in accordance with law. Law is to take its own course. Now, next would be the cases belonging to Land Acquisition Act 1894 and Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The first case is Government of NCT of Delhi and another versus Shivdat Sharma, wherein it was held that the acquisition proceedings shall not lapse if the award has not been made as on the commencement of the Land Acquisition Act 2013. The next is the case of the Secretary, the Department of Land and Building and others versus Anjit Singh, dead through LRs. It was held that if compensation has not been paid due to inter se dispute between the co-owners, thereafter it will not be open for the respondent landowners to make a grievance that once the compensation was not paid, the acquisition is deemed to have lapsed. Hence, Honorable Supreme Court set aside the order passed by the High Court that has allowed the writ petition filed by the landowners herein and declared the acquisition with respect to the land in question is deemed to have lapsed under Section 24, subsection 2. Next is the case of Revenue Divisional Officer versus Ismail Bhai. In this case, the land was acquired in 1981, but the compensation was not yet paid. The authorities were directed to make the payment of compensation within 2 months, and it was also held that the value of the said land cannot be computed at the rate less than ₹2 250 per square yard, which is supported by the evidence brought on record by the landowners. Another case is New Okla Industrial Development Authority versus Rameshwar alias Ramesh Chandra Sharma, dead through legal and another, in which it was held by Honorable Supreme Court that it cannot be disputed that the landowners whose lands have been acquired under the provision of Land Acquisition Act are entitled to a reasonable and just compensation at par with other similarly situated landowners. Next is the case of S. Shankaria versus Land Acquisition Officer and Revenue Divisional Officer, Pedapalli, Karimnagar. In this case, it was held that the purpose for which acquisition is made is also a relevant factor for determining the market value, thereby referring to the case of Basava versus Special Land Acquisition Officer and Nelson Fernandez versus Special Land Acquisition Officer, South Goa. Next is the case of Delhi Development Authority versus Damini Vadva, in which it was held the subsequent purchaser has no right to claim lapse of acquisition proceedings. Another case is Mahanadi Coalfields Limited and other versus Mathias Oram and others. In this case, Honorable Supreme Court held that persons in 4 villages which were acquired for Mahanadi Coalfields in 1988 are entitled to compensation under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Directions were issued for providing employment and resettlement packages in addition to land compensation. Next case is Delhi Development Authority versus Krishan Lal Arora. Relying upon the case of Indore Development Authority versus Manohar Lal and others, it was held that in case possession has been taken, compensation has not been paid, then there is no lapse. Similarly, if the compensation has been paid, possession has not been taken, then also there is no lapse. Compensation has to be determined under the provisions of Act 2013. Now coming to the case under Limitation Act is Messrs. Lakshmi Srinivasa R and P Boiled Rice Mill versus the state of Andhra Pradesh and another. In this case, Vijayawada's appellate deputy commissioner, commercial tax, who was also the first appellate authority, dismissed an appeal because a delay in filing the appeal was long. Honorable Andhra Pradesh High Court upheld this order. Honorable High Court noted that the petitioner had challenged an assessment order dated 18th of January 2018 before it. On the same day, the writ petition was dismissed at the stage of admission by order dated 7th of March 2018, allowing the petitioner to avail the statutory remedy under Andhra Pradesh Value Added Tax Act. However, the petitioner availed said remedy after 60 days, that is beyond the maximum period that may be condoned under law. Hence, the appeal was dismissed as barred by limitation. In appeal, Honorable Supreme Court bench noted that the period from the date of filing of the writ petition on 24th of February 2018 and the date on which it was dismissed was not entertained should have been excluded in this case. Honorable Supreme Court observed that the time period excluded under Section 14 of Limitation Act cannot be counted for the purpose of computing the period for which delay can be condoned. Allowing the appeal, the bench directed the appellate authority to examine the appeal on merits. Reliance was placed upon Consolidated Engineering Enterprises versus Principal Secretary, Irrigation Department, and Kalpraj Dharamshi versus Kotak Investment Advisors Limited. Next are the cases from motor accident compensation claims. The case is Sidram versus the Divisional Manager United Insurance Company Limited. It was held that even in the case of permanent disablement incurred as a result of a motor accident, the claimant can seek, apart from compensation for future loss of income, amount for future prospect as well. The entire law regarding determination of compensation was discussed. It was also held that just compensation should include all elements that would go to place the victim in as near a position as he or she was in before the occurrence of the accident. Courts should be mindful that a serious injury not only permanently imposes physical limitations and disabilities, but too often inflicts deep mental and emotional scars upon the victim. Another case is Balukrishna Chavan versus Reliance General Insurance Company Limited. It was held that if the liability of the insurance company is decided and they are held not to be liable, ordinarily there shall be no direction to pay and recover. In all cases, such order of pay and recover would not arise when the insurance company is not liable, but would in the facts and circumstances be considered by Honorable Apex Court to meet the ends of justice. Now coming to the cases from Narcotic Drugs and Psychotropic Substance Act. The first case is State of Himachal Pradesh versus Angrezo Devi. In this case, Honorable Himachal Pradesh High Court had acquitted the NDPS accused by allowing the appeal on the ground that the prosecution has failed to establish that the seized material is not the genesis of a plant of Papaver somniferum L or any other plant which is notified by the central government under Section 217 of the Narcotic Drugs and Psychotropic Substance Act. However, it was held by Honorable Supreme Court that if the seized contraband is found to contain morphine or meconic acid, it is sufficient to establish that it is an opium, poppy as defined under Section 217 of the Act. Next case is Intelligence Officer Thiruvananthapuram versus KK Noshad. In this case, the quality of neutral substance is not to be excluded and to be taken into consideration along with the actual content by weight of the offending drug while determining the smaller commercial quantity of the narcotic and psychotropic substance was reiterated by referring to the case of Hira Singh versus Union of India by Honorable Supreme Court. Now coming to the cases from Negotiable Instrument Act. The first case is Pawan Kumar Goyal versus State of UP and others. Now the question before Honorable Supreme Court was whether the amendment in the complaint and the impleadment of an additional accused subsequent to the filing of the complaint is permissible. The argument that an additional accused can be impleaded subsequent to the filing of the complaint merits no consideration once the limitation prescribed for taking cognizance of the offence under Section 142 of NI Act has expired. More particularly, in view of the fact that neither any effort was made by the petitioner at any stage of the proceeding to arraign the company as an accused, nor any such circumstances or reason has been pointed out to enable the court to exercise the power conferred by proviso to Section 142 to condone the delay for not making the complaint within the prescribed period of limitation. Another case is Jan B. Jose versus Santosh. In this case, the trial court dismissed a check bounce complaint since the complainant could not prove that he could lend the accused rupees 9 lakh. Honorable Kerala High Court upheld the trial court order. However, in its appeal, Honorable Supreme Court held that the accused accepted his signature on the check, Section 139 presumes an enforceable debt or liability. The presumption in Section 139 of NI Act is rebuttable. Thus, the accused can contest the existence of legally enforceable debt or liability, thereby setting aside the trial court order. Reliance was placed upon T. Vasant Kumar versus Vijay Kumari, Rangappa versus Sri Mohan, and Kalamani Tex versus P. Balasubramaniam. Now, the next case belongs to POCSO Act in the case of the state of Maharashtra versus Dr. Maruti. Here, unidentified persons were accused of sexually assaulting minor tribal girls at the school's dormitory. During the investigation, the hostel superintendent and 4 others were arrested. The victim girls were taken to a doctor authorized to treat girls at the facility. After the investigation, it was indicated that the doctor who examined the girls knew about the crimes. The victim girls also gave testimonies under Section 161 CRPC. The doctor was arraigned as an accused under Section 19 subsection 1 of the POCSO Act. It required the accused, upon learning the commission of offense, to inform the Special Juvenile Police Unit or local police. However, Honorable High Court quashed the proceedings against the accused, finding no evidence to link him to the crime. However, Honorable Supreme Court set aside the said order and held that non-reporting of sexual assault against a minor child, despite having a knowledge, is a serious crime, and more often than not, it is an attempt to shield the offenders of the crime of sexual assault. Now, the next case is from Sarfaesi Act. It is Mrs. Leela Amma Matthew versus Messrs. Indian Overseas Bank and others. In this case, the bank secured a property under Sarfaesi Act. The 54-cent secured asset was auctioned. After inspecting the property, the plaintiff offered rupees 32 lakh for 54 cents of land. The plaintiff filed a suit claiming that he had paid total sale consideration of 54 cents of the land and that the sale certificate and the sale deed were executed for 54 cents. However, the plaintiff was only given possession of 39 cents of the land, so he is entitled to damages or compensation for the 14.40 cents, which was less than 54 cents he paid. The trial court decreed the suit. However, Honorable High Court reversed the trial court decree and dismissed the case. The original plaintiff appellant approached Honorable Supreme Court. It was held by Honorable Supreme Court that Honorable High Court had seriously erred in holding that the suit was barred by Section 34 of Sarfaesi Act. It is required to be noted that the suit was for damages or compensation with respect to the balance land which could not have been decided by the DRT or appellate tribunal. Section 34 of the Sarfaesi Act shall only be applicable in a case where the debt recovery tribunal and or appellate authority is empowered to decide the matter under Sarfaesi Act. Thus, the court set aside the judgment passed by the High Court and restored the decree passed by the trial court decreeing the suit. The court also imposed cost of rupees 25,000 on the bank to be paid to the plaintiff. Next case is from service matter. The case is Chief Executive Officer Zilla Parishad Thane and others versus Santosh Tukaram Tiwari. In this case, the Zilla Parishad requested immediate recruitment of ambulance driver at its primary health centers on a contractual basis till the contracting process for supplying or providing driver on contract basis is completed. Eventually, the procedure began. Respondent number 1 was appointed temporarily and on a contract basis as a driver for 2 months, and an agreement was formed with the terms and conditions. The contract-based temporary character of the candidate's appointment was a condition. If the Zilla Parishad driver is appointed at the prescribed place, the driver's appointment will be terminated. The respondent number 1, that is the driver, sought permanence after 9 years of work. He then petitioned Honorable Bombay High Court for regularization and permanency. Meanwhile, respondent number 1 driver's appointment was terminated when an outsourcing agency was hired. However, Honorable High Court granted the petition and directed the respondent number 1, that is the driver, to continue. Honorable High Court also set aside the decision of termination, albeit no such plea was made and ordered regularization and permanency since he had been a driver for more than 9 years without brake or with artificial brake. Zilla Parishad petitioned Honorable Supreme Court. It was held by Honorable Supreme Court that the order of regularization cannot be based on the basis of continuity of service for a longer period on a contractual basis, more particularly when a policy decision was taken to avail the services of other drivers. Thus, Honorable Supreme Court set aside and quashed the impugned order of the High Court and allowed the appeal. Next is the case of Amit Singh versus Ravindranath Pandey and others. In this case, the court reiterated that in matters related to inter se seniority, any departure from the statutory rules, executive instructions, or otherwise must not be inconsistent with the requirements of Article 14 and 16 of the Constitution. The court said that the seniority cannot be reckoned from the date of occurrence of the vacancy and cannot be given retrospectively unless it is so expressly provided by the relevant service rules. The last case would be from Specific Relief Act, which is V.S. Ramakrishnan versus P.M. Muhammad Ali. In this case, under the agreement to sell, the buyer paid the seller rupees 1 crore in earnest money, rupees 65 lakhs in cash, and rupees 35 lakhs in a post-dated check dated 25th of August 2005. The seller's post-dated check was dishonored due to an attachment order. Buyer sued for specific performance. The trial court dismissed the suit because the plaintiff never had the balance consideration of roughly rupees 3 crore and 9 lakhs and consequently lacked readiness and willingness. Honorable High Court dismissed the appeal because the post-dated check of rupees 35 lakhs paid as a part sale price was returned, hence full payment was not made and there was no concluded contract for sale of the property. However, Honorable Supreme Court disagreed with the check amount on appeal. Honorable Supreme Court also noted that the trial court did not frame a specific issue on plaintiff's readiness and willingness, but gave its finding and non-suited the plaintiff. Thus, it was held that there must be a specific issue framed on readiness and willingness on the part of the plaintiff in a suit for specific performance, and before giving any specific finding, the parties must be put to notice. The object and purpose of framing the issues is to that the parties to the suit can lead the specific evidence on the same. Thus, Honorable Supreme Court remanded the case to the trial court to frame the specific issues with respect to the readiness and willingness on the part of the plaintiff. Now, this brings to an end to the session. I hope these judgments will be very helpful to our audience. So till we meet again, namaskar.